Welcome to The Explainer. Today, we are digging into a really strange legal fight between a homeowner and his HOA. And believe it or not, the whole thing hinges on a single unclaimed letter.
I mean, seriously, think about that question. Could you be on the hook for thousands of dollars in fines from your HOA, even if you never actually saw the warning notice? Well, this case, which is based on a real administrative law decision, tackles that exact issue. And the answer? Well, it shows you the surprising legal power of a simple piece of certified mail.
So, where does this all begin? Well, it's not your typical HOA dispute about, overgrown lawns or loud parties. No, this story starts with a very strange and pretty unsettling discovery at a country club in Arizona. So, get this. Someone finds a box of matches. Inside are these 3 little typed notes, each naming a location on the property. The HOA, Terravita Country Club, alleges that one of its homeowners, a Mr. William Brown, is the one who left this box. And they didn't see it as a joke. They saw it as a serious threat.
The HOA moves fast. They immediately suspend Mr. Brown from everything, and they send him the suspension notice by certified mail on December 2nd. Now, here's a super important detail. The record shows Mr. Brown did get this first letter. He signed for it. Hang on to that fact because it becomes a huge piece of the puzzle later on.
Okay, so that immediate suspension, that was just the opening act. The real conflict, the thing that lands this whole mess in front of a judge, starts with the next letter the HOA sent, the one telling him about a formal hearing. And this is where that paper trail gets really messy. So, on December 14th, the HOA mails the hearing notice. 10 days later, on Christmas Eve of all days, USPS tracking shows it's out for delivery in Texas, where Mr. Brown was staying. But he never picks it up, so of course, he doesn't show up for the hearing. And a few weeks later, that unclaimed letter gets sent right back to the HOA. So the big question is, was he ever legally notified?
And that is the million-dollar question the administrative law judge had to figure out. Mr. Brown's argument was pretty simple, right? A, I never got the letter, so how could I possibly know about the hearing? This whole thing brings us to a really crucial legal distinction that ends up deciding the entire case.
To figure that out, we have to talk about what notice actually means in the eyes of the law. And spoiler alert, it is not as simple as you might think. See, legally speaking, notice isn't just about someone physically handing you a piece of paper. The law actually has 2 totally distinct types.
Okay, so on one hand, you have actual notice. This is what Mr. Brown claimed he needed. He had to physically see it, touch it, sign for it. But then there's constructive notice. This is what the HOA was banking on. Their argument was, look, we sent the letter correctly, it got to his location, the law presumes that he had a duty to, check his mail and know it was there.
So you've got the facts, you've got these 2 different legal definitions. How did the judge rule? Did Mr. Brown have to actually have the letter in his hands for it to count?
Well, the judge did not mince words. She was incredibly direct. She found his story that the post office just never left a single notice slip for a certified letter for almost 3 weeks. She just flat out said it wasn't credible. She didn't buy it for a second.
So here's the absolute heart of the ruling. The judge basically concluded that you can't create a legal loophole for yourself by just ignoring your mail or refusing to go pick up a certified letter. I mean, if you could do that, it would be impossible to ever formally notify anyone of anything.
So that finding on constructive notice was the domino that made everything else fall into place. Because the notice was ruled valid, the hearing he missed was also valid. And because that hearing was valid, well, so were the penalties. Mr. Brown lost his case. And wow, the financial hit was pretty significant.
First up, the board hit him with a direct fine of $2,500 for that whole Matchbox incident.
But they weren't done. On top of that, they tacked on another $5,000 to cover their investigation costs. So that one unclaimed letter ended up costing him a grand total of $7,500.
So, you might be thinking, okay, that's a weird case from some fancy country club in Arizona. What does that have to do with me? Well, if you live in any kind of community with an HOA, it actually means a lot.
Here is the big takeaway for every single homeowner out there. The burden isn't just on your HOA to send you a notice. The law says you have a responsibility to be on top of your own mail. If your HOA can prove they sent that letter correctly, the responsibility flips, and it's on you.
So that's the central lesson here. Dodging that little slip for a certified letter isn't some clever legal move. It's a huge risk. This case makes the answer crystal clear. In the eyes of the law, what you should have known can be every bit as powerful as what you actually did know. And that
is a tough lesson that all started with a simple, unclaimed letter.